All right. My name is Christy McGregor. I'm a partner at Copeland Ashcroft. I work in the Tauranga office and I've been here for about 2 years. And I am presenting with Georgia. Georgia, do you want to just do a quick intro?
Kia ora everyone, I'm Georgia. I'm a very new solicitor at Copeland Ashcroft and based in Dunedin.
So just letting you know that we are recording this webinar for future use, just to be aware in terms of any contribution that you might give. And we do have quite a lot of content to cover in the presentation. We're going to try to get through it as quickly as we can, but leaving time for some questions. So there is a question functionality on the side of your screen. If you go into the meeting chat, you're welcome at any stage to put your questions in there. If I see it pop up and I feel it's relevant and can answer it at the time, I will try to answer it for you. But otherwise, we'll try to deal with those at the end. We do hope this is as interactive as possible, bearing in mind that I think we might have close to 60 people once we get started. So there are quite a lot of you. So welcome. I think probably all of you will know Copeland Ashcroft. We're a workplace law firm. That's all that we do. So we do employment law, health and safety and immigration, and we are located throughout New Zealand. Perhaps if you can move to the next slide. Georgia, thank you. So these are all the places that we are located. So we are all throughout New Zealand. We have 5 partners at the various offices, and we are able to be wherever Findex have offices as well. Right, moving on. These are the things that we hope to cover today. So firstly, we will explore the concept of what the corporate veil is. And then we're going to go through instances where the corporate veil is pierced. And that is within the employment jurisdiction. So we're going to firstly begin in terms of health and safety, and many of you will be aware of director and officer obligations and liability specifically under the Health and Safety at Work Act. And then we'll move on to the more general employment law context and circumstances where the Employment Relations Act and the Equity and Good Conscience jurisdiction allows the court to pierce the corporate veil. And we'll go through some relevant case law examples to give you an idea as to when this type of situation happens so that you can contextualize it. And we'll talk about the potential risks for employers and related parties to employment relationships, for example, sister companies that may be joined and have liability for employment-related obligations and how that might be planned for. So moving forward to what is the corporate veil? So this brings me back to Law School 101. Why do we establish a company and what's the objective? So it's generally known that a company is established to be a separate legal entity from the directors who established that company. So it is a freestanding entity in its own right, and it can be a party to litigation. And the liability of the company is generally limited to the assets of the company. So there is no looking beyond the company to the directors for personal liability. That would bring you more into a situation like a sole trader scenario. So it's a well-established principle in common law that a limited liability company is separate, and it's a separate legal entity following its incorporation. So it is removed from the personal identities of its directors, and it allows the company to have its own assets and liabilities, which also are not owned or owed by the directors. And it gives the individuals involved a level of protection from claims that are related to the company. So it allows people to operate businesses and take commercial risks that they might otherwise not if they were doing on a sole trader basis, for example. And they wouldn't take personal liability unless required to, for example, giving of personal guarantees. So why would the court lift the corporate veil when there is a good economic reason for doing that and having the veil and giving people protection so that they feel more freely able to operate and take risks in business? So there are established circumstances where the corporate veil is pierced or lifted. So you're looking behind the facade of the company and its trading name. And so generally speaking, the directors aren't treated as liable for the company's debts, but there is a discretion to look behind that. It is only exercised in limited cases, though. So that is where there would be a substantial injustice which the court cannot countenance. So to me, that seems like quite a heavy test. And it must be judged against the fact that corporate structures and a separate corporate identity are the legitimate faces of commerce. So they're firmly and deeply ingrained in commercial life, genuinely and honestly used. They should not be set aside. So there needs to be something compelling for the court to look behind those structures. So it is something that, in general terms, the courts are reluctant to do. But as you'll hear as we progress, this principle isn't necessarily being strictly upheld, and there's more and more decisions that we're seeing now where the courts in the employment jurisdiction are going beyond the corporate veil and around this very high test for looking beyond that. So we have some case law around that, and the courts have said that ownership and control are not in themselves sufficient to pierce the corporate veil. So your typical company that might be husband and wife, sole directors and shareholders, just because they have ownership does not mean that the court should look behind the structure that they've established. The veil should only be pierced if there's impropriety, and that must be linked to the use of the company structure to avoid or conceal liability. So that in itself, again, is quite a high standard. So it's not the ordinary course of trading. And you need to identify that there's been control by the wrongdoer, so the person that sits behind the corporate structure, and the impropriety as well. Both of those things must be demonstrated. So this legislation, the Health and Safety at Work Act, is a substantial departure from the corporate veil principle. And many of you, if you are directors or have involvement in operations and health and safety in your businesses, will be well aware of the substantial changes that came about as a result of the Health and Safety at Work Act. So this legislation came into force in April 2016 and created the ability for the courts to penalise directors and other officers personally for failing to carry out due diligence on health and safety risks. So that is significant, and it's pulling in those people and the decisions that they're making and actually requiring that they be held liable for the governance in terms of health and safety that they're performing in their organisation. So this is a substantial change. So when we look at who this could cover, so directors, trustees, and other officers. So an officer is considered to be a director or a partner or person occupying a position in a body corporate or an unincorporated body that's comparable to that of a director. So it includes a person who holds a position that allows them to exert significant influence and control over the management of the PCBU, such as a trustee. So we do have cases where trustees, for example, have been prosecuted in relation to their health and safety obligations. So the PCBU has an obligation under the Health and Safety and Work Act, and then the officers of that PCBU have to exercise due diligence to ensure that the PCBU complies with their duty and obligation. So in terms of the due diligence obligations that have to be undertaken, the nature of the business, so the type of business, the position of the officer, and the nature of the responsibilities undertaken by the officer will be taken into account. And in terms of what that means, so due diligence includes taking reasonable steps to acquire and keep up-to-date knowledge of work health and safety matters. So if you're sitting on a board, for example, you should be thinking about those things. You need to gain an understanding of the operations of the business or undertaking, and generally the hazards and risks that are associated with those operations. So you can't be a silent director as such and have no interest in the health and safety governance of the organisation. You are required to ensure that the PCBU has available and uses appropriate resources to eliminate or minimise risks to health and safety as a result of the activities that the organisation is undertaking. It needs to ensure that the PCBU has appropriate processes in place to receive and consider information in relation to incidents, hazards, risks, and responding to that information. Ensure that the PCBU has and implements processes for compliance with its health and safety obligations, and that it verifies all of those steps. So that's quite a lot for someone to consider. For example, if you're sitting on as a voluntary trustee on a board, those are things that you should also be thinking about. And it is quite a commitment in terms of your own personal obligations there. So a breach of a duty is a criminal offence under sections 47 to 49 of the Act, and there's a maximum penalty of 600,000 and or up to 5 years imprisonment. So there's section 47, which relates to reckless conduct in respect of a duty. So obviously the bar is quite high there in terms of what might be reckless. But for that, if you're found to have done that as the officer, you can be liable to imprisonment not exceeding 5 years, fine not exceeding $600,000 or both. 48F, failing to comply with a duty that exposes an individual to the risk of death or serious injury or illness. So again, this is quite a serious breach, liable to a fine not exceeding 300,000. And 49, failing to comply with a duty, a fine not exceeding 100,000. So these things in terms of directors are actually quite significant in terms of liability, and remembering also that we can't insure against fines, we can only insure against reparations. So just to contextualize this, we've got a case that we can talk about, which is a WorkSafe prosecution against Smoke Control New Zealand Limited. And in this case, WorkSafe prosecuted a small business, Smoke Control New Zealand Limited, and its director personally in relation to the death of a staff member. And they found that the business and the director both breached their obligations under the Health and Safety and Work Act. So the court found that a reasonable officer, so somebody in that person's shoes, would have ensured robust systems and processes and procedures were in place to ensure their workers' health and safety, and that steps that were required that should have been taken by the director were neither onerous nor cost prohibitive. So in this case, Mr. Kennedy, as the director, was charged with failing to exercise due diligence to ensure that the company complied with its duties, and he failed to take reasonable steps to ensure that the company had available resources and processes to eliminate risks by ensuring that the workers were trained and competent in safe systems of work, that they could effectively identify and manage hazards, ongoing monitoring and supervision of workers to ensure that continued competency and compliance with safe systems of work, and they failed to verify the provision and use of resources and processes. So just to give you some background, in this case, it related to the death of an employee. The employee was installing fire curtains, which needed to essentially be retrofitted. He didn't have the appropriate tools to complete the retrofitting, and he used an Ozito grinder, which broke off a part of the tool and hit him in the neck, and he was found dead. It was obviously very serious. And when WorkSafe investigated, they found that there were some very basic things that hadn't been done, and that Mr. Kennedy, as the director, was there and was around, and should have been complying and doing more in terms of overseeing health and safety to ensure a situation like this didn't happen. So the worker hadn't been trained in alternative methods or how to manage the risk. There was an awareness that this worker had been removing a protective cover on the grinder previously, so he wasn't carrying out a safe process in terms of his work and exposing himself to the risk. So Mr. Kennedy was cooperative. He pleaded guilty at the first available opportunity. He came with his hands out, admitting responsibility, and that did ensure that the fine that he had imposed on him was lower, on the lower end. He was of good character, had genuine remorse, had taken remedial steps as a result, and had an early guilty plea. So it was found that he should be fined in the lower end of the middle culpability band, with a starting point of $70,000, which after those reductions was reduced down to $31,500. So as you can see, that was very personal for Mr. Kennedy, and he wasn't able to hide behind the corporate veil in terms of his health and safety obligations. Moving on, so we will talk about the corporate veil in the employment jurisdiction. There are multiple examples that we have around situations where the authority or the court is finding directors and other entities personally liable in relation to employment liabilities. There's various sections of the Employment Relations Act that allows this to happen, and the court is doing so increasingly, and we do have some concern around the increasing trend. And for us, the message that we would like to get across to directors is you should be aware of your employment obligations and ensuring that those are met, because if you're in a situation, for example, where your company won't be able to meet those liabilities to employees, that there is a very real potential that there could be litigation where you're added as a party and sought to be personally responsible for those liabilities. So it's definitely something to think about. So in terms of where we can get around the corporate veil, those situations include identifying the true employer. So there is discretion for the employment court to join a party to the claim under Section 6 of the Act if it considers that it is appropriate to do so. So Section 6, the inquiry into who is the employer and employee, is an objective inquiry, and it involves weighing the evidence to reach an informed assessment as to who on the balance of probabilities the employer is. So we often think of Section 6 around employee versus contractor claims. So am I an employee? Are you my principal, or are you the employer? So an employer doesn't have to be an entity recognized by law. It can be a person. In terms of other ways of finding personal liability, there is the ability to seek compliance orders under Section 137(4) of the Act. The authority may make a compliance order against a person who isn't a party to the proceedings to ensure that earlier decisions are complied with. So compliance orders are generally sought either when we've got a determination and that determination hasn't been complied with and it needs to be enforced, or there has been a Section 149 agreement between the parties, generally reached at mediation or settled separately, where one party has breached. And you can imagine that there will be circumstances where the determination hasn't been satisfied, perhaps because the company that's been found liable doesn't have the resources to pay. So there is a wish to add a person on to take personal liability for that, or where you've got an agreement and the company itself is not complying with that. If you have the ability to add a director, then you have much more scope to ensure things happen, even if it's just having the director ensure that the company is in funds. So if you know that the director can exert significant control and the company's saying we can't pay, but we know that the director could move funds, then there is some value in including the director in those compliance order proceedings. Then there is personal liability for employment breaches. So Section 142 of the Act allows a labour inspector or an employee to recover from a person who's not the employee's employer wages or money that is payable if there has been a default to the employee. The default is due to the minimum breach of the employment standards. So we're talking about minimum wage, Holidays Act entitlements and the like. And the person is involved in the breach within the meaning of Section 142. So, sorry, 143. A person is involved in a breach if they've aided, abetted, counselled, or procured the breach. So, if a director, for example, has reorganised funds and moved funds out of a company so that the company is not in a position to pay, that person may have aided or abetted that breach. Has induced, whether by threats or promises or otherwise, the breach, has in any way directly or indirectly knowingly concerned in or been a party to the breach, or has conspired with others to effect the breach. So there's some leeway here for the ERA to wrangle in and a party who is not the obvious party, as in not the employee and employer. In terms of that breach, though, where there's a breach by an entity such as a company, partnership, limited partnership, or sole trader, the person who occupies a position in the company may be treated as a person involved in the breach, so that can be added as a party only if that person is an officer of the entity. So you need to be considered an officer, and that definition of officer feeds into this a similar definition in terms of the health and safety definitions of officer. So that is a director, a partner, a general partner in a limited partnership, a person occupying a position that's comparable to a director if the entity isn't a company, partnership, or limited partner, and also any other person occupying a position of influence in the entity, so they can exert significant influence over the management or administration of the entity. So that's quite a wide definition, and it allows the court to find solutions to ensure that employees are getting their entitlements, and allows some quite good ability for employees to and the labour inspector to enforce. And then we've got an ability to join sister companies and directors for cost purposes. So where the court has made determinations and now needs to make orders in relation to costs. So Section 221 of the Act gives a broad discretion to allow parties to be joined to proceedings, and the test is to allow the court to dispose of the matter more effectively, to allow a cost order to be made. And I'll give you an example of that in the case law. And Section 189 of the Employment Relations Act also gives the court the jurisdiction to make determinations, decisions, and orders as it sees fit, based on the principles of equity and good conscience. That is quite wide. And it has been used to lift the corporate veil in situations in an employment context. And we have also Section 221 of the Act, which allows joinder, waiver, and extension of time. Those things can be considered as well. So it will get, once we get into the cases, you'll get a little bit more context as to when the court has allowed those things to occur. So moving on to the next slide. This is around Section 6 of the Act, and the ability to identify the true employer of an employee when they're seeking remedies. So the employment court can join a party to a claim under Section 6 where it considers that it's appropriate. So, for example, where an employment agreement names the trading name of the company as the employer, but it was signed in the personal name of the director. So, in terms of being careful in not creating liability, there's some learnings from the cases around if you are a director, you sorry, in the representations you're making to your staff, you want to be very careful that those key documents like employment agreements, letters of offer, and those types of documents are entered into by the company, and there's not a false picture given that it is creating any kind of personal liability or agreement with you as a director. So some easy things, for example, including your full company name, so that it's clear that the person is dealing with a limited liability company, and when you're signing off, it's on behalf of the company rather than signing off as you personally. So as an example of this section, we have Pilgrim and Attorney General, which is one of the Gloria Vale cases. It was an earlier Gloria Vale case where there was consideration given to who the employer was of the workers at Gloria Vale. And Judge Ingalls held that it was possible to have multiple employers and that the employment court has the power to identify the correct employers where a plaintiff has got it wrong. So this is the on motion type orders where the court can actually of itself consider what the facts are and make its own determination as to who should be a party and who should be deemed to be an employer. So the court said that a Section 6 inquiry is to be done objectively, weighing the evidence to reach an informed assessment as to who on the balance of probabilities the employer is. And that is an intensely factual exercise. So it means that the court needs to dig into any documentation that there might be in terms of that relationship, and what practically is happening in terms of who has the control and direction of the staff. And an employer doesn't need to be a recognised entity at law for the purposes of Section 6. So it can be a person as opposed to a company. So in this case, the employment court found, in terms of using its equity and good conscience jurisdiction and looking at Section 6, that the overseeing shepherd was the employer and that the overseeing shepherd was liable to account for alleged breaches against the plaintiff's employees. So in that case, it was a hopeful Christian who passed away, and then it moved to Howard Temple, who was an overseeing shepherd. They were the true employer. They were the people who ultimately pulled the strings, and that they required the Gloria Vale residents to willingly submit to the jurisdiction of the overseeing shepherd. So in terms of their documentation and arrangements, it was clear that the overseeing shepherd was the employer, and the court found from looking into how their relationships practically worked that that should be named to be the employer and added as a party in terms of Section 6. Just a note on that though, before a party can, you can move to the next slide, that's fine. Before a party can be added as to the proceedings, they have the opportunity to be heard. So the court won't just add them, they will be advised of the court's intention and have an opportunity to be heard before that order is made that they're added as a party. Moving on to the next case, we have Citizens and Good Food Trading, and that is a company that is in litigation, in liquidation. So this is a case where the employee, she worked at the deli section at Nosh, Mount Maunganui, So this may be something some local people have some knowledge of. During her employment, Good Food Trading Limited operated the store, and Mr. and Mrs. Blennerhast were directors and equal shareholders of the company. The company ceased operations of the store sometime after she was dismissed. And the backstory to the dismissal was apparently she was reported to have been picking up sausages without wearing gloves. And she was dismissed as a result of that. It appeared that there wasn't any kind of fair process that was taken in terms of her dismissal, and she sought remedies in relation to that. Unfortunately, though, the company itself was placed into liquidation by resolution of its shareholders. And what that meant, obviously, was it made it difficult for the Miss Sissons to seek her remedies. She had applied to the ERA for a finding that she was unjustifiably dismissed. And once aware of the issues with the company, she sought to have the husband, Dr. Blennerhast, added as a respondent in order to pursue her claim. In support of that, her written employment agreement actually didn't identify the company name as being the employer, so it wasn't Good Food Trading Company Limited as it should have been in the employment agreement, making it clear that she was dealing with a limited liability company. It actually only referred to it by its trading name. So the employer there was listed as Nosh Mount Maunganui, which obviously is not a legal entity and wasn't the correct employing entity. It presented her with an opportunity then to seek remedies against the employer who signed that, against the director who signed the offer of employment in his name. So from her perspective, the wording of the employment agreement didn't indicate that the company was her employer. He signed it for and on behalf of Nosh Mount Maunganui, and she applied a legal principle of the doctrine of an undisclosed principle. And that doctrine, she said, should operate to make Mr. Blennerhast personally liable for the remedies that were awarded if she was to establish her personal grievance for unjustified dismissal. So her claim was considered, and it was determined that the doctrine of undisclosed principle did apply. So what the court said was, where an agent having authority to contract on behalf of another makes the contract in his or her own name, so he signed for Nosh Mount Maunganui, concealing the fact that he or she is a mere representative. So he really was signing on behalf of Good Food Trading Company Limited. The doctrine of the undisclosed principle comes into play. By this doctrine, either the agent or the principal, where discovered, may be sued. So definitely something to keep in mind, that all of your employment documents should, particularly your employment agreements, should correctly say the employer name, not the trading name, in order not to invoke that particular principle. So it was held that Mr. Blennerhast, more likely than not, had authority and had not disclosed Good Food Trading Company Limited as the principal. And therefore, Ms. Sissons, the employee, was entitled to elect to pursue him personally for remedies, and there was an order made that he was personally liable for the remedies to her. The remedies included $10,000 for humiliation, lost wages, and costs. So you can see that there's some real care required in entering into employment agreements and other documents to ensure that there isn't an incorrect understanding around who the employer is, because it appears that the court will entertain those types of legal principles which will allow employees to gain what effectively might be considered a fair result. Interestingly, though, obviously there was a Mrs. Blennerhast in that case. She didn't sign the letter, and therefore she wasn't personally liable. And so there is the risk that he took by signing that document himself, in that all the liability sat with him as opposed to being shared between the directors. Moving to compliance orders, so section 1374 provides that the authority may make a compliance order against a person who is not a party to the original proceedings. So generally speaking, that's not the employee and the employer entity, to ensure that earlier decisions are complied with. So before making a compliance order against a person who is not a party, the authority must give the person the ability to appear or be represented. So again, it's that same concept as in the Gloria Vale case. So compliance orders, as I've already explained, are orders where a person hasn't observed or complied with specified obligations, whether that be in terms of a determination or a Section 149 record of settlement. So generally where someone's been awarded compensation and it's invoked where that hasn't been fulfilled. So for example, payment hasn't been made in accordance with that, or something that was required to be done in terms of a Section 149 agreement hasn't occurred. So the authority can order that a trustee, director, employer, or employer's representative do a specific thing, or start or stop an activity and obey the order within a specified time. So the employee, when they seek compliance, must allege that they've been affected by the non-observance or non-compliance giving rise to the proceeding. And again, the person has an opportunity to be heard. So we have a case to give you an example of that, Allen Chambers Limited and Palabon. So in this case, the incorporated employer failed to pay compensation to an employee, and the authority can order the director, so in this case, Mr. Chambers, to use his position of control to ensure that a liability is met by the employer company. So it's a wide discretion which enables the authority to consider other persons that might be helpful in terms of ensuring the compliance occurs. So in terms of the third party that may be subject to the compliance order, it doesn't specify that they must be in an employment relationship. So we don't have to establish, for example, that the director is actually the employer. The focus is whether that person can exercise control over the liable party. So for example, if a director has significant control over a company, they have a current account and they make a call on that current account and obtain all the money owed to them from the business, leaving the company with no money available to pay the employee liability that sits there. They are a party that the court might order be putting the company back into funds to ensure that those the liability is complied with. So in this case, the authority had ordered that the company pay the employee Palabon $10,800 in wages, holiday pay and compensation, and also costs. And unfortunately, the company didn't comply, and Palabon sought orders not only against that company, but also against Allen Chambers Limited and Allen Chambers. They found that ZRNL was Palabon's employer, but ACL, the company that it was seeking compliance against, was a holding company for his employer entity, and that Mr. Chambers owned 100% of that company's shares, and he was also sole director of both companies. This determination was challenged in the employment court, and it was directed that the employer, so ZNRL, was to pay Palabon the sum required. However, in terms of compliance, Mr. Chambers, who was the sole director of the employer entity and Allen Chambers Limited, the holding company, was ordered to make the payment as an agent of the employer. ACL, so the holding company, was ordered to advance to the employer whatever funds necessary, if any, to enable Mr. Chambers and the employer to comply with the compliance orders which had been made. And the employer was ordered to pay Mr. Palabon interest, and Mr. Chambers and ACL had to take whatever action was necessary to ensure that that payment was made. So in terms of the rationale for that decision, that there was a totality of evidence which confirmed a close relationship between those entities, and the relationship as holding company and sole director as both. Moving to the next case. Georgia, I think you're going to talk about this one, Ugon and Star Moving Limited.
I sure can. So as you can see from the slide, these were the initial awardings at the ERA for Star Moving to pay. So obviously this included about $28,000 in lost wages to pay to Mr. Ugon and about $27,000 in compensation, $6,000 in penalties. So Star Moving did not pay this, and subsequent proceedings were brought to the authority. So the facts of this case was Mr. Biggs was listed as a second respondent in these proceedings. Neither Star Moving or Mr. Biggs filed a statement in reply. The authority then ordered Mr. Biggs to ensure that Star Moving complied with the payments that had been ordered to make to Mr. Ugon. So Section 1372 of the Act, the authority has a wide power to order anyone that is a party or witness to a matter to do any specified thing or to cease a specified activity. In this situation, it was ordering Mr. Biggs to take all necessary steps to ensure that Star Moving complied with the payments that had been ordered to pay to Mr. Ugon. So despite Mr. Ugon not being party to the employment relationship, he was easily brought into the litigation under the Employment Relations Act provisions relating to compliance orders. So as on the slide, there are the penalties. So it then made a compliance order for these awards. A compliance order was also made to the company's director to take all steps necessary to ensure the employer complied. The figures were paid, however, not until nearly 2 months after the date stipulated by the compliance order. So the delay in total was around 6 months. So in terms of the imposition of the penalty, the court found it would be appropriate to impose penalties against the employer despite the payment being eventually made. It looked at a previous case where it was held that although the primary purpose of a compliance order is to compel compliance, it also has the purpose of imposing a sanction for non-compliance, even if this just amounted to a delay in the end. The court held that only in rare cases would non-compliance be excused. So in terms of penalty quantum, the court began by considering the sanctions that should be imposed against the director. It held that the failure to comply could not be regarded as mere inaction. There was no meaningful difference between inactivity and disobedience. The court chose to impose a $20,000 penalty against the employer. $15,000 counted for the absence of any reason for the failure to comply. This was then increased to $21,000 to represent the director's track record, the deliberate nature of breaches, and the need to deterrence. The court then applied a minor deduction of $1,000 to acknowledge that the orders had eventually been complied with. The court directed that $10,000 of the $20,000 fine should be paid to the employee directly. It then also warned the director that if any other cases came before the court, he faces serious risk of custodial sentencing, which was obviously quite a departure from regular case law. So further sanctions, so the court recorded that the employer Star Moving had breached the compliance order but declined to impose further sanctions against the employer to avoid the risk of double counting. So sort of key takeaway points from this case, it's a very interesting case as it seems like multiple piercings of multiple veils, not just Star Moving but also the director's previous wrongdoings under the veil of other companies. The court directly referred to the director's previous wrongdoings as reason for imposing the sanctions, which is quite rare. And the court went as far as to say that if director was caught again, the custodial sentences would be considered. So the court made a clear distinction between the sanction and the sanction being placed on the director and not Star Moving. So it feels as though the veil has been completely obliterated in this case rather than just simply being lifted. So following on from the authority cases in this matter, the matter escalated to the employment court following Star Moving and Mr. Biggs failing to comply with previous made orders. So by the time the matter was heard in the employment court, Star Moving had paid the sums in owing. And I think that is the case.
So quite a scary case in terms of the court and the ERA being willing to exercise the discretions that it has in the legislation, and in particular to ensure that compliance happens. So if you're in a situation where you are a director of a company and that company is found to be liable for employment related obligations, you should be aware that employees are increasingly, where they feel that the employer entity isn't paying or isn't complying, are increasingly looking to directors and adding them, and the court and the ERA are willing to do that. So again, there's all the more incentive to ensure that you are ensuring that the company is complying with its obligations, because there is risk that when it comes to compliance, that you may be looking at personal liability or being required to do things in the background which ensures that your company has funds in order to meet that liability. And so we're not just saying, for example, this company is in liquidation. Take your luck with the liquidator. Go and see if you can recover from them. Actually, employees are actively using these provisions to get around the uncertainty that comes with that, and the different corporate structuring arrangements that might happen, or directors putting companies voluntarily into liquidation to ensure that they are paid without having to rely on their order of priority in terms of liquidation. So definitely something to be aware of. Moving on to personal liability for employment breaches. So we've talked about this, where a labour inspector can recover from a person who's not the employer wages or other money payable that has been a default in the payment of wages or monies payable, that the default is a breach of the employment standards. So that could be minimum wage or holidays entitlement, and that the person involved in the is a person involved in the breach within the meaning of 142W. So again, involved in a breach is where you've aided, abetted, counselled or procured, induced, knowingly or directly or indirectly, knowingly concerned in or party to the breach, or has conspired with others to effect the breach. But you need again to be in the position of an officer, and we've talked about the relatively wide definition of what an officer is. So again, this is the labour inspector's ability to look behind and pierce the corporate veil to ensure that those minimum entitlements in the employment standards are met. And the case example we have here is a prosecution of Southern Taxis Limited. So Southern Taxis were a small taxi operation, husband and wife team. They ran their taxis much like the Uber situation, which if any of you have got the news, are employees from the appeal decision. Um, and in that case, it was determined that the arrangements that they'd made with the workers were not legitimately contractors. They were actually deemed employees. So those employees were able to pursue Southern Taxis for their minimum entitlements, including minimum wage and holidays entitlement. Um, and Mr. The owners of Southern Taxis said, well, look, we genuinely engaged these people as contractors. We didn't know that we were committing a breach of minimum requirements. We legitimately set up these arrangements believing that they were able to be relied on, and therefore, how is it that we could possibly be involved in a breach? And that argument didn't fly. They were held to be personally liable. Um, they were officers, obviously, they were directors. They said genuinely believed that they were contractors, not employees. And they, therefore, because they genuinely believed the arrangements were legitimate, shouldn't be liable. And the matter went all the way to the Court of Appeal to consider the question of uh, how you can establish liability. And the Court of Appeal said that the directors didn't need to know that the drivers were employees. That wasn't an essential fact that they needed to know and understand to be held liable for the breach. It was sufficient that they needed to know the essential facts that led them to be knowingly concerned in the breach. So they needed to know the essential facts that established the contravention. So in this case, they did know the essential facts. They knew about the rostering, that the drivers were solely allocated work by them. They allocated the work. The drivers drove branded vehicles. They couldn't operate on their own behalf. They didn't own their own vehicles. They couldn't subcontract out. And the company was actually deducting PAYE, which again indicated that they were employees. So the Court of Appeal remitted the question back to the Employment Court, but essentially from that decision, the owners, the shareholders and directors were personally liable for their minimum entitlements of their drivers that they'd incorrectly deemed to be contractors when they were employees. Moving on to Live and Creative Nursery Limited. So we've got an employee who was a graphic designer. When his employment ended, the company owed him about $10,000. He approached the authority to investigate his unpaid wages, but in that time, the company was placed into liquidation. And the issue that he wanted to look into was whether Mr. Miller, as the sole director and shareholder of the company, could be held personally liable. And it was found that he could be personally liable and that he needed to pay costs to him as a result. In this case, it was relevant that Mr. Miller, as director, had reached an agreement with Mr. Wee that he would pay his wage arrears by instalments. So he had knowledge of the default in terms of he knew that the company hadn't paid his wages and that he knew that it was a breach of the Wages Protection Act. And that he therefore was aware of the breach and is personally liable to pay the wage arrears because the employing company wasn't able to pay that because they were in liquidation. Crichton and Earthworks Limited. Georgia, is this one of yours or is this mine?
I can happily go for it.
Alrighty.
Cool. So this one is sort of a case example of going against the trend. So the employer company, it's facts of the case with the employer company didn't pay the sums owed under Section 149 of the Record of Settlement. So the employee sought compliance orders, including order to leave under Section 142W and Section 142Y of the Act to bring proceedings against the managing director personally for a breach of employment standards. The court ordered that the employer company make the various payments due, and the court held that the shortfalls in payment were the result of breaches of record of settlement, not employment standards under the Act. Thus, there was no basis to make orders against the managing director personally pursuant. So Section 142Y of the Act didn't apply here. So sort of key takeaways from the case is it does give the idea of the court doing a bit of a flip-flop when they decide when to hold a director personally liable. Prior to this case and on similar facts in Marshall and 7 Kids in 2019 ERA case. In this case, the court held that there were payments have not been made under Section 149 for the record of settlement, that the director of companies should be ordered to ensure these payments are made. So the ERA reasoned that the directors are agents of the employer. So interesting that the court in this case of the Crichton and Earthworks Limited didn't follow the reasoning in this instance, but they have in other following cases. I guess it might indicate some uncertainty in the trend overall, but this seems to be sort of an outlier of what we're seeing, including the approach from WorkSafe side of the corporate veil as well. So the trend overall does appear to be shifting despite this sort of outlier case.
So the technical issue here was the 149 agreement was what was sought to be complied with as opposed to a minimum entitlement. And the Section 149 agreement did make reference to that the company would pay the minimum holidays entitlement, which wasn't complied with, which is a standard provision at the very end of a record of settlement that the employee confirms that they're not giving up any entitlements that they have, and the employer was found to have some liability in terms of that. But because it was a record of settlement that was enforcing that requirement, not a minimum employment standard, it was a technicality that meant the director wasn't liable, which is odd because the court does seem to find ways and means around things. I agree, Georgia. So this next case, we're talking around joining sister companies and directors for cost purposes. So Section 221 of the Act enables parties to be joined to proceedings to dispose of any matter before it more effectually, and it has been used to join sister companies and directors for the purposes of considering a cost order against them. So Kid and Equity Realty, in the employment court, a defendant was joined to the proceedings under 221 for the purposes of considering a cost order being made against him. So that's Mr. Kidd. By the time that costs were fixed, the defendant company was insolvent. So obviously there was a wish to gain the cost somewhere, and that was sought against the director, Mr. Kidd. He was joined because it was asserted that he was the guiding mind of the company and that he was guiding the litigation strategy and the various orders that were being sought and pursued, which were the subject of the argument that costs should be awarded given that they were unsuccessful. So the argument was that Kidd himself, as a director, was pursuing the litigation for his own interests, and therefore he should be responsible to pay those costs. All right, let's move to the next case. Henderson Travels, I think this is yours too, Georgia.
So this is in 2021, the authority had ordered Henderson Travels to pay Mr. K unpaid wages for working on a public holiday pay, and to refund a premium she had, Ms. K, premium she had paid in contravention to the Wages Protection Act. It also awarded her compensation under Section 123(1)(ci) and 123(1)(b) of the Employment Relations Act. And imposed a penalty on the company of $12,000. Of that penalty, $9,000 was directed to be paid to Ms. K. Henderson Travels unsuccessfully challenged this in 2023, resulting in an uplift of some of the compensation the authority had ordered it to pay. So I think the following amounts, I think it was cut down to: compensation was $30,000. There was another $38,000 payment and unpaid wages of $9,000. So in addition to the amounts payable to Ms. K, the penalty imposed was unchanged. Henderson Travels was placed in liquidation by special resolution of shareholders on 8th November 2023. A statement of the company's assets and liabilities made by the liquidators showed it had no property, vehicles or equipment, debtors to collect or cash in the bank. Its creditors were listed as Inland Revenue, a bank and Ms. K. Its liabilities were described as unknown, even though the judgment establishing company's indebtedness to Mrs. K was issued several days before the shareholders' resolution was passed. So Ms. K applied to join the proceedings Flight Experts NZ Limited as a sister company for the purposes of making it liable for the cost. This was on the grounds that Mrs. K was successful and entitled to costs. In an earlier judgment on 15th of July 2022, an indication was given that Henderson's Travels potential exposure to costs might be dealt with in joining Flights to Expert proceedings, so it had already been sort of on the cards. Flight Experts is the sister company of Henderson Travels and has funded the litigation. And Flight Experts continued to trade and operate the business that was previously run by Henderson Travels. So Henderson Travels was unlikely to be able to satisfy the judgment or pay any costs, and it is just in all the circumstances that Flight Experts be joined. So the court actually applied the test in Kid and Equity Realty to warrant cost award against a non-party or director. It would need to be shown that there was relevant impropriety on their behalf, or that they were not acting in the company's interest, but rather their own interest. So the court agreed that the test in Kid had been satisfied, and Mr. S, as director of Flight Experts and Henderson Travels, went beyond a mere funder, and clear commitments were made on his behalf about the company meeting future cost orders. The purpose of those comments was to provide assurances to the court and Mrs. K that potential future cost orders were adequately addressed. Those assurances were intended to enable Henderson Travels to continue with litigation it could otherwise not support. Additionally, the financial commitment of Flight Experts assisted Henderson Travels in avoiding order of security for costs. It is highly likely that an order for a security for costs would have Henderson Travels challenged well before preparation was required for the substantive hearing. So basically, without the financial assistance from the sister company, they wouldn't have been able to continue. So, sorry. So Mrs. K incurred the cost that she is now bearing, and in turn, that meant the Henderson Travels obtained a significant advantage, and it would not have otherwise enjoyed by being able to continue litigation to test the authorities' adverse findings. So Mr. S. commitment meant that Henderson Travels enjoyed what the Court of Appeal referred to as a heads-I win, tails-you-lose approach by seeking the overturn of the authority decision with little or no real downside if the decision was adverse to it. So the court granted the application, and Flight Experts was then joined to the litigation as purposes for fixing costs. So yeah, interesting example here of sort of what it takes for a sister company to be joined in terms of lifting the corporate veil.
So I think the lesson there is if you're involved in a sister company and your company, your sister is facing litigation, be very careful before you put your hand up and make any kind of promises with regards to funding or payment of costs, because the result of saying will ensure that the company's in funds, so that in order for security of costs wasn't made, was ultimate liability. So moving on, I'm just going to go quickly through this last bit, piercing the corporate veil in terms of 149, which is the court's equity and good conscience jurisdiction. So the court has a wider jurisdiction to make determinations or decisions as it sees fit in accordance with the principle of equity and good conscience. The court is able to do that while admitting calling for evidence that it sees fit, whether that's strict legal evidence or not. And I'll just talk about the Square One case. In that case, there was an appeal against the refusal of the Employment Tribunal, so this is an older case, to strike out the appellant, which had been named as one of the respondents in the personal grievance proceedings. So in that case, the company A, was controlled by T. It sold its assets to another company B, and that was also controlled by T. So he was the common director and shareholder. A few days before that sale happened, where the assets of A went to B, an employee of A had been given a warning and was dismissed. The intention was that the company A's employees would transfer across to B, but in this case, because the employee was dismissed, she wasn't offered employment with B. And when the employee pursued her personal grievance claim against A was a worthless shell because all of the assets of A had been transferred to B. The evidence suggested that T had arranged the transfer of assets from A to B to avoid the effect of a relationship property claim. And on appeal, Judge Colgan indicated that in terms of the lifting of the corporate veil and the equity and good conscience jurisdiction, it was not essential that the sham was for the purposes of it would enable the corporate veil to be lifted, and it wasn't necessarily the purpose of the present challenge. So in this case, it wasn't that T moved the assets to B to avoid the employee claim. The underlying sham related to the relationship property claim. The court could, in equity and good conscience, lift the veil to prevent a company from avoiding its obligations where artificiality or a sham was apparent, and in this case it was. Things were being moved but not for a legitimate purpose, but it wasn't specifically because of the employee. And it concluded that the employee was in reality employed by company B at the time of their dismissal, and it would be free to lift the corporate veil and fix the company B that had the assets with such liability as might be appropriate. So in that case, although there wasn't an intention to defraud the employee, that was the net result, and the court was able to intervene and was able to determine that the employer was a different entity. Moving on to Bennett and Michaels, in that case, the plaintiffs believed that they were being employed by corporate entities established by Mr. Michaels. It became apparent to them that the entities were being used by Mr. Michaels to avoid legal responsibility, not only to the employees but to creditors. So in this case, it was a wages claim, and the employees were actually never paid. And Mr. Michaels was claiming to be involved in companies. He was accepting payments into the companies and was actually taking them for himself. So the court found that the company structure was being used to conceal fraud, and therefore the court lifted the corporate veil and found that Mr. Michaels was personally liable for the wages claims that the employees made, because he in effect had received all of the funds of the company, and he was using the company as a falsity. And then we've got two cases at the very end, which are against the same employer, Blackburns Limited. We have Kim and Blackburns Limited, and Gustella and Blackburns Limited, which are very similar. Kim was an employee. Murray Osmond was a director. Ms. Kim resigned from her role and she brought various claims, including constructive dismissal. And the constructive dismissal was based on the fact that she hadn't been paid in accordance with her employment agreement. And in that case, the authority accepted that somebody would consider that they'd been constructively dismissed if they weren't being paid. And the authority lifted the corporate veil and found that Mr. Osmond was personally liable for arrears of wages, and that Osmond, the director, was knowingly concerned in breaches of employment law by the company. So in terms of that, he was involved, that he aided the breach or was knowingly concerned in it, so he was aware that they weren't being paid. He held a position in the company that meant he could be treated as a person involved in a breach of the employment standards. And the Court of Appeal endorsed the position that a person is knowingly concerned in a breach if they have actual knowledge of the essential facts giving rise to that breach, or are willfully blind in relation to those facts. So that is the same reasoning as the Southern Taxis case. So you don't have to know that the claim necessarily would be successful. For example, that your workers aren't contractors, but they are in fact employees. You just need to know the essential facts that would establish that they're employees to be deemed to have that knowledge. Mr. Osmond was the sole director. He was involved in the decision making for the business, and he had direct knowledge of the business's circumstances, including its obligation to pay wages and holiday pay and keep records. So leave was granted to recover wages from him personally. If BBL, which was then in liquidation, was unable to pay those arrears. However, a little subnote, Mr. Osmond was declared bankrupt. So it means that even the piercing of the corporate veil may not have had the desired effect for Kim and for the other employee who was also successful against Blackburns. So we'll jump past that case because we're now over time. So the key takeaways that you should take from this are: directors and shareholders can't always hide behind the corporate veil in employment matters. It's very clear in the health and safety space that this has changed with the new legislation, and also that there are numerous mechanics available in the employment jurisdiction to ensure that employment obligations are met, either in the way of minimum entitlements, but also in relation to compliance obligations. Incorporation doesn't give full protection, and there can be personal liability. There's uncertainty at the moment in terms of when the discretion will be used and when it won't. There has been some flip-flopping in terms of the case law, but there does seem to be a genuine trend of a great willingness from the ERA and the Employment Court to find an outcome that is considered fair to the employees. So where there is an ability to ensure that employment obligations are met, and if that means looking at a director and the circumstances can justify it in terms of the various mechanics that are there, the ERA and the Employment Court do seem quite willing to do that. So the key point here is, as a director, then given these obligations, you do need to consider that where things go wrong, there is real risk in relation to personal liability, particularly when you have knowledge that employment obligations aren't being met. And so if you do have an awareness of that, the best approach is to ensure that you make sure that the company is compliant, so you don't get yourself into a situation where those types of mechanics need to be used against you and you are found personally liable, because obviously it won't necessarily create a fair result, particularly if there are multiple directors and it's just you who's in the firing line. So Thank you. Georgia, did you have anything further that you wanted to add?
No, you pretty covered it very well, I think.
Thank you. Alice, did we have any questions? I can't see any questions.
No questions.
No questions. Thanks everyone for coming along. I appreciate this is a topic we haven't really touched on too much before. And we do think it's an important thing to be thinking about. And some of you, I understand, are professional advisors and are working with businesses in relation to meeting their obligations. We're really happy to talk to you around making sure that your clients or contacts are compliant and how you might go about that. So thank you so much for your time. Apologies that we went over, but I hope you've taken a good amount out of this. And if you have any questions, feel free to reach out. I'm here and will be around today. So if you did want to speak to me offline, feel free to do so. Thanks, everyone.